Good morning, ladies and gentlemen. We will starting today the third section to our conference, and I will announce it small exchange regarding the speakers to that section. We will start this section in the place of Professor Dragic. Will be Associate Professor Udroiu. He will present his topics. And because he's a hurry, please agree to start first that section. So, Mr. Professor Udroiu, you have the floor, please.
Thank you very much. I'm very honored to be here at this conference. I'm here with Rodrigo. I'm a judge at the High Court of Position in the department, and also associate teacher at the University of Oradea in the field of criminal proceedings and criminal law campus. I choose to be here because also conference made by the University of So, for this conference, I prepare a speech about the special procedure applicable in criminal proceedings concerning maritime and river offense. There are special rules because in criminal proceedings we have a criminal procedure code that determines the various form of competence and jurisdiction. So I will not insist on the general procedure rules, but I will in the written paper that I will deliver to the conference volume. I will have a detailed presentation of functional jurisdiction, subject matter jurisdiction, personal jurisdiction, and territorial jurisdiction in criminal proceedings as are drafted in criminal procedure code. For the moment, I want to point out only the main topic in the general rules, that is Article 41 from the criminal procedure code, that determine the territorial jurisdiction of the courts and the prosecutor office attached to the courts in order by four criteria: forum delicti comissi, forum depressionis, forum domicilii, and forum victima. These are the main alternative topics that courts and also the prosecutor office attached to the court are using for determine the territorial jurisdiction in general criminal proceedings. But in the field of the offenses against safety of civil navigation, or offenses against shipping regime, or offenses against order and discipline on the board ships, there are two important provisions drafted in Article 2 to 22 and also 23 to 30 of the law number 191 from 2003 that drafted the special competencies in the area of these crimes. So, with regard of territorial jurisdiction, law number 191 from 2003 stipulates that territorial jurisdiction of the court and public prosecutor office is the following: Tribunal of Constanța and also the prosecutor office attached to the Tribunal of Constanța for the counties of Constanța and Tulcea, the territorial sea, the Danube up and including nautical mile 64. And also Tribunal of Galați and the public prosecutor office attached to the Tribunal of Galați for the counties and the Danube from nautical mile 64 to kilometer 1075. So in this area, yes, in this area of offenses against safety civil navigation, offenses against shipping regime, or offenses against order and discipline on the board ships, this special procedural rules determining the competence point out that only 2 tribunals and only 2 prosecutor office attached to the tribunals has the competence for investigating and judging the crime in the whole country, except in some special provision that made up some competencies for the Court of Appeal or even for High Court of Cassation, but only in theoretical field a case can be the Court of Appeal or the High Court of Cassation. In practice, all the cases or the investigation that are made in Romania in this area, in this shipping regime crimes, are made by Tribunal of Constanța and the prosecutor office attached to Tribunal of Constanța, and also Tribunal of Galați and the prosecutor office attached to the Tribunal of Galați. When these offenses are committed on the vessel outside Romanian waters, jurisdiction lies to Tribunal of Constanța, the public prosecutor office attached to the Tribunal of Constanța, and if the vessel is maritime one, the Tribunal of Galați and the public prosecutor office attached to this tribunal. However, if it is found that offense is committed in Romania on the Romanian territory on a vessel shipping under Romanian flag, is not one provided by the law 191 from 2003. The general procedure rules laid down by the Article 41. So the 4 criteria that I already mentioned, forum delicti comisii, forum de presionis, forum domicilii, and forum domicilii victime, are in this exceptional situation enforced. And in this structure, in which we have a territorial competence, but also a subject matter jurisdiction, we identify some special investigation body that are implying the criminal proceedings alongside General Prosecutor Office or Prosecutor Office attached to the Tribunal of Constanța and Galați. And this is the Border Police. The Border Police has a special determination and jurisdiction by Government Emergency Ordinance number 104 from 2001. With a special structure from General Inspectorate of Border Police, Cross Guard Territorial Inspectorates for Border Police, Territorial Services of Border Police, Sector of Border Police, Group of Vessel of the Border Police, Point of Contact in the Border Police. Which will be presented in the following presentation by Professor Dragic. So I'm not. I just wanted to point it out alongside the procedural rules, and what is important to mention that the investigative body of the Romanian Border Police carry out criminal investigation for any crime that is not necessarily given the competence of other investigative body. So they have a special competence in the maritime and fluvial field, but also they have plenty of competence of jurisdiction in the other fields that can go to other prosecutor office. So in this metamorphosis of procedural rules, border police has main importance in sustaining activity of the prosecutor office from the competencies and jurisdiction as I presented before, but also they have a particularity that whenever they determine other kind of crimes committed in the course of the investigation of fluvial or maritime offenses, they are also allowed to investigate and go with a case with the prosecutor office that can pass the case to the courts, but not from the Constanța or Galați, but also to other jurisdictional territorial competence. So, in conclusion, the existence of a certain specific features of the offense is covered by law number 191 from 2003 has justified the introduction into the Romanian legal system of a special procedure rules for both criminal prosecution or trials in the first instance. The procedural rules are explicitly regulated in order to determine the hypothesis of strict interpretation derogating from the general procedure rules in this special area of crimes that are against safety of civil navigation, shipping regime, or against order and discipline on the board of the ship. Thank you very much for your invitation.
Thank you very much, Professor Hudroiu. Professor Hudroiu is the most important specialist in criminal procedure in Romania, and we are very honored from his presence to our conference. If you have questions to Mr. Hudroiu, can do it now. See, the jurisdiction has an important role in the settlements of relations that fall under the jurisdiction of law of the sea or in maritime law. And if you have any questions, Okay. So thank you very much, Professor Hudroiu, and we are waiting your written work to be published in the
I already have a draft and I'll finalize until September, I think.
Yeah, thank you very much. So we will continue that sections. And we will respect the speakers. So I will give the floor to Mr. José Manuel Sobrino Heredia, first Vice President of AssIDMer University from Coruña. He has communication, I think that he will present in the French, la stratégie de sécurité maritime de l'Union européenne et sa projection dans la mer Noire. Mr. José Manuel Sobrino Heredia, you have the floor. Thank you very much.
Merci, Monsieur le Président. Je voudrais tout d'abord remercier les organisateurs de me donner l'opportunité de participer dans cette colloque. Ça me donne l'opportunité en tant que citoyen d'une ville qui se trouve tout à l'ouest de l'Europe. C'est une ville où se trouvent les ports les plus occidentaux de l'Union européenne. Et je viens à parler ici aux ports les plus orientaux de l'Union européenne. Et je vais parler de la stratégie de sûreté maritime de l'Union européenne qui s'applique dans mon port pour voir si ça peut s'appliquer également ici dans la mer Noire. Donc mon sujet, comme vient de dire le président, c'est la stratégie de sûreté maritime de l'Union européenne et sa projection sur la mer Noire. Quelques idées générales. Avec l'adhésion de la Bulgarie et de la Roumanie en 2007 à l'Union européenne, et l'Union européenne est devenue un acteur nouveau de la mer Noire en tant qu'État, en tant qu'entité riveraine de la mer Noire. Elle est concernée par la instabilité croissante dans cette région, ce qui met à l'épreuve sa capacité de devenir un fournisseur de sûreté dans la région pontique. La mer Noire est considérée par l'Union européenne comme une autre mer régionale européenne. Mais l'Union n'a que partiellement et tardivement pris en compte la situation dans cette région. Tardivement, car l'attention de l'Union européenne vers la mer Noire est assez récente. Elle a pris en compte la situation dans cette région après l'élargissement vers l'Est de l'Union européenne, et partiellement parce que l'Union européenne a privilégié et privilège aujourd'hui les aspects économiques par rapport aux aspects sécuritaires. L'intégration économique, ça va être les points forts de sa préoccupation dans la région de la mer Noire. Aujourd'hui, dans un contexte de conflit armé qui finit par affecter l'ensemble de la mer Noire, on peut se demander si la stratégie que l'Union européenne développe depuis 2014 dans des mers et océans européens et non européens pourrait être appliquée également dans la mer Noire. Et cela dans un contexte de violence maritime extrême. Ma présentation examine cette possibilité. À cette fin, je vais d'abord examiner les raisons pour lesquelles l'Union européenne a introduit une dimension maritime, sa politique de sécurité, de sûreté européenne. Et après, je verrai si certaines des mesures contenues dans sa stratégie de sûreté maritime peuvent être appliquées à la mer Noire. Les points forts de ma présentation, c'est une question. Savoir si les conflits armés dans la région pourraient conduire à un renforcement de cette stratégie ou au contraire à témoigner de son inopérance. L'Union européenne, en tant que puissance maritime civile, je ne vais pas décrire ses caractéristiques parce qu'elle est très bien connue, et en tant qu'acteur majeur de la maritimation croissante de l'économie et du commerce mondial, dépend de la sécurité des mers et des océans. Les menaces et risques croissants qui pèsent sur ces espaces maritimes ont conduit les autorités européennes à inclure la sécurité et la sûreté dans sa politique maritime. Cette préoccupation explique l'adoption de la stratégie de sûreté maritime par le Conseil de l'Union européenne en juin 2014, complétée par un plan d'action établi le 16 décembre de 2014, mis au jour en 2018. Ces instruments ont été révisés assez récemment, en 2023, dans le but de renforcer et de les adapter à l'évolution des menaces maritimes qui pèsent sur l'Union européenne. Et cette stratégie a donné lieu à un nouveau plan d'action qui s'articule autour de différents thèmes. Surveillance maritime, échange d'informations, gestion des risques, protection d'infrastructures maritimes critiques, recherche et innovation. Des sujets assez vastes, mais qui tous ont en commun la vocation de protéger les intérêts maritimes de l'Union européenne. Cette stratégie qui combine des mesures préventives et correctives visant à protéger le domaine maritime européen et se soutient sur une double approche. Une approche transsecteur visant à améliorer la coordination entre les différents acteurs concernés, sécurité publique, sécurité privée, sécurité intérieure, sécurité extérieure, coopération civile, coopération militaire. Seulement une petite acclaration. Dans l'Union européenne, il y a plus de 400 autorités différentes dans ces domaines. Donc, c'est assez complexe. La coordination et la cohérence entre toutes ces autorités. Une approche transsecteur, mais également une approche régionale, cherchant à répondre aux différents défis des bassins maritimes de l'Union européenne, également les points chauds clés tels que le golfe de Guinée, la Corne de l'Afrique ou bien la mer Rouge. Cette stratégie de sûreté maritime de l'Union européenne, les plans d'action successifs, ont fourni depuis 2014 un cadre global pour la dissuasion et la réponse aux défis de sécurité, de sûreté maritime de l'Union européenne, à renforcer la capacité de l'Union européenne à répondre à ces menaces, notamment en lui permettant de mener ses propres opérations aéronavales ou de coopérer avec des autres partenaires extérieurs, voire l'OTAN, et d'encourager la production conjointe des navires, des bateaux de guerre à ces effets. La stratégie de sûreté maritime et son plan d'action définissent une série de mesures, de la mise en œuvre dans la région de la mer Noire semble, dans certains cas, et à mon avis, réalisable, dans des autres cas, difficilement réalisable, et dans des autres cas, clairement impossible à mettre en place en œuvre dans la mer Noire. Il y a des mesures qui, il me semble, sont applicables. En fait, ils s'appliquent déjà dans la mer Noire. Par exemple, les mesures concernant la connaissance de la situation maritime, la surveillance et l'échange d'informations entre les autorités civiles et militaires de la région. Des mesures garantissant que les informations de surveillance maritime recueillies par une autorité civile ou militaire puissent être utilisées par des autres autorités en partageant cette information. À titre illustratif, quelques exemples. Les cadres communs de partage d'informations et CII, les projets européens, CLOSAI, les systèmes opérationnels de surveillance maritime et frontalière, Copernicus, complété par les services satellitaires Galileo, l'Agence européenne des gardes-frontières et gardes-côtes, ou bien le système de surveillance de défense maritime européen MARSUR. Ce sont des actions qui peuvent s'appliquer facilement à la mer Noire. Des autres mesures prévues dans la stratégie de sûreté maritime et qui pourraient également être applicables dans la mer Noire concernent le renforcement des capacités maritimes européennes. Par exemple, ces mesures visant à développer les technologies à double usage et la coopération en matière de normalisation et de certification cherchant à améliorer l'interopérabilité civile et militaire et la compétitivité industrielle. Il ne faut pas oublier que les capacités militaires appartiennent aux États membres et sont utilisées par les États membres. L'amélioration des capacités de prévention des conflits et des réactions aux crises, c'est un autre domaine couvert par les stratégies de sûreté maritime applicables à la mer Noire. Ce sont des mesures qui visent à prévenir les conflits, à réduire les risques et à améliorer la protection de l'environnement marin ainsi que les infrastructures maritimes critiques. Des progrès ont été déjà réalisés dans ce domaine, par exemple en organisant des exercices maritimes réels à l'échelle de l'Union européenne, surtout en ce qui concerne la sécurité des ports, les menaces cybernétiques et hybrides. Il y a des autres activités clés, surtout en pensant à la région de la mer Noire, et ce sont mesures visant à accroître la résilience et la protection des infrastructures offshore telles que les gazoducs, les câbles sous-marins, les installations énergétiques offshore, etc. Sans doute, l'attaque du gazoduc Nord Stream 2 en mer Baltique en septembre 2022 a encouragé ces mesures, l'adoption de ces mesures. Des développements ont également eu lieu dans le domaine des technologies de défense, comme l'illustre l'adoption des projets communs, tels que la corvette patrouille européenne, qui est un nouveau type de navire de guerre tout à fait adapté également à la mer Noire. Les améliorations des capacités de lutte anti-sous-marine et de neutralisation des munitions non explosives, qui représente bien sûr actuellement un grave danger pour la navigation dans la mer Noire. La protection des infrastructures critiques et la localisation et l'élimination des munitions non explosives, des armes actives et des armes chimiques en mer Noire constituent un domaine de l'action de l'Union européenne en coopération avec la OTAN est possible et urgente. À cet égard, l'action de l'Union européenne dans le cadre de sa stratégie pourrait appuyer des initiatives telles que celles lancées par la Turquie, la Bulgarie et la Roumanie en janvier 2024, créant une coalition maritime pour éliminer les mines flottantes russes et ukrainiennes dérivant en mer Noire et entravant la navigation civile. Un autre domaine prévu par les stratégies de sûreté maritime tout à fait applicables à la mer Noire se concentre dans l'identification et le regroupement des possibilités de formation disponibles en matière de sûreté maritime dans des modules communs de formation maritime. Et je vais finir avec un domaine où, par contre, les possibilités d'application des mesures dans la mer Noire paraissent plus compliquées. Ce sont les actions militaires qui se déroulent en mer et dans différents endroits où il y a des situations d'instabilité qui mettent en danger les intérêts maritimes de l'Union européenne. Ce sont des actions qui peuvent impliquer l'utilisation de moyens militaires et sont des actions, une partie de ces actions rentre dans le cadre de la politique de sécurité et défense commune de l'Union européenne et des autres actions qui sont en dehors de ces politiques. Je vais commencer par les actions qui sont très bien connues dans le cadre de sa politique de sécurité et défense commune. L'opération dans l'océan Indien et face aux côtes de la Somalie et le golfe d'Aden, l'opération EUNAVFOR Atalanta que l'Union européenne déploie depuis 2008 dans cette région, fondamentalement pour
permettre la liberté de navigation des navires, surtout les navires dans les programmes des Nations Unies sur l'alimentation. Sont des opérations armées qui permettent de combattre la piraterie, mais qui sont déjà été élargies pour lutter contre la pêche illégale, non déclarée, non réglementée, etc. Les résultats de cette opération sont un résultat assez positif, mais aujourd'hui, elle est dans une situation, on pourrait dire, plus compliquée à conséquence du conflit de Gaza, à conséquence de ce qui se passe dans la mer Rouge, à conséquence de la participation des milices Houthis dans cette région. Une autre opération militaire, c'est l'opération EUNAVFOR IDIMI, au large des côtes libyennes de 2020, et la dernière opération, peut-être la plus controversée et la moins réussie, à mon avis, c'est l'opération EUNAVFOR ASPIDES, que c'est une opération que l'Union européenne, certains pays membres de l'Union européenne, ils l'ont mis en place dans la mer Rouge pour protéger les navires qui naviguent dans cet espace vital pour le commerce international et également pour le commerce de l'Union européenne. Cette dernière opération, qui n'a pas arrivé à arrêter les attentats Houthis, il y a un jour où il y a un bateau qui était attaqué, et un autre jour, il y a un bateau qui est pas seulement attaqué, qui a coulé conséquence de ces attaques, a mis en lumière les désaccords entre les États membres de l'Union européenne, et on trouve que pas tous les États membres sont disposés à participer dans l'effort militaire et financier que suppose une opération de cette envergure. Ce sont des opérations, je suis en train de définir, très coûteuses, tant au niveau de la mise en place et surtout de l'entretien. C'est pour cela que l'Union européenne, en dehors de sa politique de sécurité et de défense commune, a essayé des autres solutions. La plus connue, c'est utiliser les moyens militaires que les États membres ont dans les régions où il y a un conflit pour coordonner cette présence militaire par des opérations qui s'appellent présence maritime coordonnée. Ces présences maritimes coordonnées sont des opérations que l'Union européenne mène dans le golfe de Guinée, qui est un golfe infesté par des attaques de pirates et que l'Union européenne veut étendre dans des autres régions de l'océan Indien et pourrait également être envisageable avec, bien sûr, quelques précisions dans la mer Noire. En définitive, la politique de sécurité et défense commune, et c'est la base des opérations aéronavales, c'est une politique où les décisions doivent être prises à l'unanimité. Et il y a certains conflits où les États membres ils ne sont pas tout à fait d'accord pour mettre en place ces opérations. Des situations comme celle des conflits armés entre la Russie et l'Ukraine, qui a évidemment des conséquences dans la mer Noire, n'a pas une unanimité en ce qui concerne la réponse entre tous les États membres de l'Union européenne. Donc, je vois très difficilement une implication dans la région. Conséquence, la défense des intérêts maritimes rentre sous le parapluie de l'OTAN et l'Union européenne est mise à l'écart. Donc, cette stratégie de sûreté maritime, en ce qui concerne l'utilisation et l'usage de la force maritime, devient inopérante. Et c'est tout. Merci.
Muchas gracias, el profesor Sobrino Heredia. Merci beaucoup, monsieur le professeur. On est très reconnaissant que la mer Noire, c'est pas dans ce moment-là que la frontière nationale de la Roumanie, c'est aussi la frontière de l'Union européenne, la frontière de l'OTAN aussi. Et pour ça, à mon avis, il faut des efforts communs de renforcer cette région-là en avenir. Merci beaucoup encore une fois. Et à la fin de cette section, on a prévu une part de questions et de réponses et on attend votre question dans cette part-là de cette question. To end of this section, provide a part of Q&A and we are waiting for you with possible questions then. So we will continue that sections and we will asking Fiammetta Borgia from University degli Studi di Roma, Tor Vergata, to present us a very interesting topic, current challenges for the Black Sea marine environment. Please take the floor.
So thank you, President. Good morning, and I'm very grateful for this opportunity, for this invitation to Professor Claudia and Professor Ronta, and I'm very happy to be here. My topic today will be about current challenges for Black Sea environment. And my presentation will be very simple and I hope fast, I don't know. And the starting point will be the current challenging environmental, so the new environmental issues, but then I will move on the legal framework in governing, in managing this environment, this Black Sea. And I will say that this governance, this type of governance can be conceived like a regime complex. So I will apply the theory of regime complex in Black Sea, I will try. And at the end, I will see if this regime is strong enough to fight the current challenge in environmental protection. And because very often a regime complex will tend to this systemic order. I will evaluate if it is possible in the Black Sea today. New environmental challenges. Black Sea as challenging in pollution that are very old in reality. But today we have some other topics like climate change issues or overfishing or geopolitical dynamics. That is a nice way to say war in the Black Sea. And also the use of new technologies in the Black Sea. All these challenges are new, but the governance mechanism for the environment is old. And the current regional governance in environmental protection is a cooperative effort to involve many countries, the coastal countries and international organizations. But I would say it's an effort, it's not so realistic. Why I chose the theory of a regime complex for Black Sea? Because this theory is interesting because it's a concept that stress how legal framework are not creating a vacuum very often, and in particular in environmental issues, environmental governance, there is generally an overlapping and interaction and fragmented activities of international organization, of legal instruments, hard law, soft law, mechanism of various types. So this is, I think, also Black Sea can be a good example of regime complex. And I will try to demonstrate it. Here in this slide, I choose to stress the legal framework that is directly addressed to Black Sea and to the Black Sea environment. The starting point of each regime complex is hard law. So also here we have the frame, the general frame that is UNCLOS. UNCLOS for many states, but we know that Turkey is not part of UNCLOS. So the provision in protection of marine environment and the provision that are set by UNCLOS for stemming close sea can be that can be applied to the state that are part of UNCLOS, but I'm not so sure that that provision are also applicable to Turkey. As a general law, yes, but I'm not sure that all the provision in UNCLOS in environmental issues are today customer law. But anyway, what is interesting is that also in UNCLOS there are provisions to coordinate the UNCLOS with other instruments, and there is a general call to more cooperation. And this cooperation was done in Black Sea, in particular in environmental issues, because in 1992, it was signed the Bucharest Convention, that is the core of the protection of the environment in the Black Sea. And if we think to the times in which the convention was signed, it was a very great achievement. Today, maybe the convention is quite old, but I would say that it's a good starting point to prevent pollution and to manage environmental issues in Black Sea. The idea, the objective was establish a legal framework for cooperation and coordinated action in the basin. And it was done by creating the Black Sea Commission that is today in charge of managing environmental issues. But what I also found interesting is the relation with the other international instruments. So the convention called for a coordination with other international instruments, universal instruments or regional. And what I found very simple, it's the settlement of disputes, because in the Bucharest Convention, apparently only negotiation and peaceful means can be used to avoid contracts or to resolve disputes, and this is very risky, I think. The convention is based also on several protocols. We have 4 protocols. 3 of them were signed at the time of convention and are attached to the convention, and another is quite new. The objective of all the protocols are preventing or eliminating one source of pollution. And I will be fast here, and I don't will be fast in my writing, but here, for reason of time, I have to do. For example, in the emergency protocol, that is the other protocol attached to the convention, what I found that is interesting is the duty of notification when there is an emergency and the identification of a national focal point. This identification of national point, I think, will bring the power of the national states again in this time. So today can be a problem in a time in which states have difficulties to cooperate and to make a dialogue. And also in the dumping protocol, there is the designation of a competent authority, that is a national authorities again, and there is a call for cooperation in exchange of information and also in information to the dumping. Okay, and then we have the last protocol that is for biological diversity, for protection of biological diversity, and the idea of all this system is to bring the situation of Black Sea at the time of 1960. This is the main objective, but it is an objective probably too big. Ci sono io. I don't know why. Okay. Okay, and what I found, okay, in the Bucharest Convention, there is the establishment of a commission, the Black Sea Commission. The Black Sea Commission is a body that has the participation of all the coastal countries, and the voting system is unanimity of present and is able to do resolution and decision, so also binding decision. But it's also true that this commission was not so strong at this time, and even if the functions are big and the functions are very different, in the Black Sea Commission was strong, especially in exchange of research data and in communication, like collaborative research, and not very effective at normative or legal level. The Black Sea Commission works also through the Strategic Action Plan that was revised in 2009. This revision was effective. It was also due to the climate change, and also was due to the idea to fight the new challenges in environmental issues and environmental protection of Black Sea, and the Black Commission was not strong in this 40 years, but what I want to stress is also that I didn't mention other international organizations or other international agreements or instruments that can be applicable in the area. But there are other actors. For example, the Black Sea Economic Cooperation Commission that was analyzed yesterday has also a program, an agenda in which the activity is also promoting sustainable development and regional cooperation. And also in the basin, we have the presence of the European Union also in the protection of in marine environment and the IMO. This is for just to explain that yes, the mechanism, the governance mechanism is a regime complex. Why? Because we have a legal instrument, the core instruments, we have a commission that is not strong. Then we have other international organizations that are directly, indirectly linked to the environmental issues, and then we have also other agreements. So it's true that the situation is fragmented and is overlapping, and also there are many programs in this kind of cooperation. For example, the variability of national capacity and resources to implement the regulation given by the Black Sea Commission, for example, and the inconsistent enforcement of the obligation that is consequent. So it's true that we have a regime complex, and the analysis of the current legal system shows what? The sort of interaction between hard law, soft law, several institutions, and proliferation of international actors, because we have also to consider stakeholders. So private companies, NGOs, all these. And these factors increase the governance gap, and these reveal the need for a more legal integrated system. This integration is usually a natural process evolution of regime complex. But here, I'm not sure that the time is now. So I'm not sure that the Black Sea Commission, the Black Sea environment, the Black Sea legal framework in environmental issues are ready to go forward a systemic coordination because of geopolitical dynamics, that I say, but also because the regional cooperation in this time is mainly focused on maritime security and on security, and I will say also on defense. So that's why I don't see the natural trend of a regime complex in this area. Usually, regime complex tends to a systemic coordination. Here, we need the involvement of European Union in the Black Sea Commission. That is the basic to make a cooperation that is effective. So, in conclusion, we can see that there is a mechanism of governance in environment, but it's not effective, and I'm not sure that can be effective tomorrow. Thank you for your attention.
Thank you very much, Professor. Yes, the protection of the Black Sea must not only be achieved from a military point of view, but also from an environmental point of view. And that is why this communications is particularly very interesting. Thank you very much. So we will continue it, and we ask Mr. Professor Tullio Scovati from University degli Studi di Milano, Bicocca. Yes, he have very interesting topic, naming the marine protected areas in regional seas, including the Black Sea. Mr. Professor, please, you have the floor. Thank you very much.
Thank you. I'm very grateful to AssIDMer and the two Romanian organizing universities for the invitation to present a report at this conference. I have been invited to speak about marine protected areas, including in the Black Sea. But as I am here speaking about law of the sea in the Ovidius University, I will ask Mr. President the permission to make a short addendum at the end of my presentation relating to the role of Ovidius in international law of the sea. So, about marine protected areas. Mr. President, as I'm very prolix and sedentary, I need a time limit, and
I will cut your interventions. Okay, I will do very good my job. So please continue,
yes,
Professor.
you will cut my intervention.
But you have
how many minutes?
10 minutes. 10 minutes today.
10 minutes.
No, 50. You have 50 minutes. No problem.
I have 15 minutes starting from now.
Now, yes. Please don't lose the time. Thank you.
Yes. So, if we look at policy instruments, we have many invitations to state to establish marine protected areas. The last one is in the Kunming-Montreal Global Biodiversity Framework. It is a declaration adopted by the parties to the Convention on Biological Diversity in the year 2022. It states that parties shall establish by 2030 at least 30% of terrestrial, inland water, and of coastal and marine areas that are effectively conserved and managed through ecologically representative, well-connected and equitably governed systems of protected areas and other effective area-based conservation measures. That is the so-called 30/30 objective. If we look at treaties, we have the United Nations Convention on the Law of the Sea, but in fact, in this convention, there is no mention at all of marine protected areas. We can consider them as implied in Article 194, paragraph 5 of the Convention. It says that the measures taken in accordance with Part 12 concerning protection and preservation of the marine environment shall include those necessary to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species, or other forms of marine life. So we can consider that marine protected areas are implied in this kind of measures. What is important is that the provision applies everywhere into the sea. So it applies to maritime internal waters, to territorial sea, to the exclusive economic zone, and to the high seas as well. For example, we know that in the exclusive economic zone, there is a balance of rights and obligations between the coastal state on the one hand and the other states on the other hand. So the coastal state is entitled to exercise a jurisdiction. Don't ask me what is the meaning of the mysterious word jurisdiction. A jurisdiction in the field of protection of the marine environment, while other states are entitled to exercise the traditional freedoms of the sea, including freedom of navigation, freedom of overflight, freedom of laying of cables and pipelines. And these two different kinds of rights have to be balanced according to the due regard criteria. So the coastal state has to pay due regard to freedom of navigation, and the other states have to pay due regard to the right of the coastal state to establish measures for the protection of the marine environment, including marine protected areas. So I would say that the two interests are put on the same level. Then it has already been said that in the UNCLOS we find a provision for enclosed and semi-enclosed sea, where cooperation is strengthened among states bordering the same sea. Now we have the 2023 Agreement on Conservation and Sustainable Use of Marine Biological Diversity beyond the national jurisdiction. It does not apply to the Black Sea because it applies only beyond national jurisdiction, beyond the 100-mile limit of the exclusive economic zone. It applies to the Mediterranean so far as we still have high seas in the Mediterranean, but for geographical reason, as no point in the Mediterranean is located beyond the 200-mile limit from the nearest land or island, the high seas will disappear sooner or later, in my view, better sooner than later, in the near future. But the BBNJ agreement is important because it provides for some definitions which are applicable everywhere, not only on the high seas, and in particular, the definition of marine protected area. That's the first time that we have a definition of marine protected area in a treaty. It means a geographically defined marine area. I will try to scroll down the screen if I have the technical capacity. This one I'm not intelligent enough to master the electronic equipment. So I will proceed. We have a definition of marine protected area. It means a geographically defined marine area that is designated and managed to achieve specific long-term biological diversity conservation objectives and may allow, where appropriate, sustainable use, provided it is consistent with the conservation objectives. So the idea is that we have a boundary, a geographical boundary for a marine protected area. Thank you. Then we have a conservation objective, and within the area, stricter measures do apply than in the rest of the sea. And we have a definition of the second concept, area-based management tool. That's a new concept. It means a tool including a marine protected area, So area-based management tools are a broader category than marine protected area. For a geographically defined area through which one or several sectors or activities are managed with the aim of achieving particular conservation and sustainable use objectives in accordance with the agreement. So what is the difference between marine protected area and area-based management tool? The main difference is that marine protected areas are established for conservation objectives, for environmental objectives, while area-based management tools are established also for different objectives, but have an effect favorable, an indirect effect favorable also for conservation. For example, they are established for fishery purpose to prevent the depletion of biological resources, and they also an environmental objective. They are established for shipping purposes to have a routing systems of area to be avoided by ships and have a positive effect also on the protection of the environment. This difference is important because area-based management tools are included in the 30/30 objective. And as regards regional cooperation, we have several examples of regional treaties providing for the establishment of marine protected areas. The first one was established within the Barcelona system. It was concluded in 1982, the protocol concerning Mediterranean specially protected areas. Now it has been replaced since 1995 by a new protocol, but we have also elsewhere protocols, for example, in the Eastern African region, in the Caribbean, in the East Pacific, in the Antarctica, in the Austral region, the Northeast Atlantic, and also, of course, in the Black Sea, with the Black Sea Biodiversity and Landscape Protection Protocol, which was concluded in 2002, and now it has entered into force in 2011. I speak under the control of Professor Oanta, who has published an article on this protocol, and now it is in force for 4 Black Sea states, namely Turkey, Bulgaria, Ukraine, and Georgia. I noticed that Romania is missing, but probably it will become a party to the protocol. With the Mediterranean Protocol, which was the first, and in my view, is the most articulated among all the protocols, we have the idea of SPAMI, of specially marine protected areas of Mediterranean interest, which is a list. But the purpose of the list is not only to provide some satisfaction to states which propose specially protected areas, but also to oblige them to protect, according to effective measures, the area. And this category of specially protected areas of Mediterranean interests in the Mediterranean includes the so far 39 areas. While in the Black Sea, there is a list also for the Black Sea, but I'm not aware of any designation for the Black Sea so far. And according to another agreement, ACOBANS, the Agreement on Conservation of Cetaceans of the Black Sea, Mediterranean Sea, and contiguous Atlantic area, states parties are invited to establish marine protected areas for the conservation of cetacean species. There is a resolution adopted by the parties in 2007, and 4 areas of interest for cetaceans. 3 areas are established, are indicated because they have not yet been established also for the Black Sea, namely the Kerch Strait, bordered by the Russian Federation and Ukraine, at least before the present war between the 2 states. Then we have the Cape Sarik to Cape Chersones, bordered by Ukraine, and Cape Anaklia in Georgia. So we have a strong invitation, which is supported also by legal instruments to establish marine protected areas. They are not against freedom of navigation, because freedom of navigation is not an absolute right. It can be limited in certain areas for environmental purpose. And I hope that also in the Black Sea, this invitation will be possible. And now 1 minute for Ovidius. If I can go down to the last page of my presentation, still I'm not intelligent enough to master this equipment. Yes, this the last one. The last one. And again, the last one. Again. Yes, this.
Yeah?
Yes. So, you know, Gentiles, who wrote his book in 1598, this is quoted the 2nd edition, supported the freedom of the sea. He said, I shall now speak about the sea. This is by nature open to all men, and its use is common to all, like that of the air. It cannot therefore be shut by anyone. Its shore too are by nature accessible to all, as well as the banks of rivers and rivers themselves, that is to say, running water. And he quoted some authorities, taking them from classical age. He quoted Greek and Latin writers to support his position. And if we can go down with the projection, the first author he quoted in favor, no, down. The first, yes. Yes. The first author he quoted is Ovidius, a passage from the Metamorphoses of Ovidius, and the translation in English says, why do you forbid the waters? The use is common to all. Nature has not made the sun the property of anyone, nor the air, nor running streams. I have come to make use of public property. These are the verses of Ovidius, but they in a completely different context, because who speaks is Latona, the mother of Artemis and Apollo, the twins, I think, or brothers. I speak under your control and you agree. And she went to a stranger for her place, and the people of the place were very rude against her and her children, and they did not allow her to drink water of a stream. So it was in a completely different context. Latona complained because she was prevented from drinking water. But for Gentili, and later also for Grotius, who also quotes Ovidio, this is an example of things that cannot be appropriated, air and water, irrespective whether water is used for drinking or for navigation. So, in fact, Ovidius is, besides being a great poet, is also a forerunner of freedom of the sea, according to Gentili and Grotius. And thank you for your attention.
Thank you very much, Professor. Now I will ask Mr. Professor Ioannis Stirbis, and in the first I can say welcome back to the last Greek region, professors, because that region named Thomis in that period. So, Professor Ioannis Stirbis from University of Aegean have a topic named the Law of the Sea and the Black Sea Grain Corridor. Professor, please take the floor, and thank you very much for your presence here.
Thank you, President. Let me join at the outset all the other speakers in thanking wholeheartedly the organizers, the two Romanian hosts, and of course AssIDMer, our president, and Gabriela for giving me the opportunity to come to Constanza, to the ancient Greek colony Thomis, as you said, and to be able to participate in this conference that has, as for in AssIDMer, a real exchange of views. It's a real dialogue. My presentation has to deal with the law of the sea issue, which is not so much in the beginning connected to Anthros. It's mostly law of war, law of naval warfare, the Black Sea Grain Deal, the Black Sea corridor, trade corridor that has been established in order to allow safe navigation of vessels, merchant vessels that carry foodstuff, grain, sunflower oil, and some also fertilizers. In order to set the outcome of this Black Sea Grain Deal, the most important facts to keep in mind is that when the invasion of Russia started in February 2022, Ukraine was a major exporter of grain, sunflower, maize, wheat, barley, all the kind of grain, had a lot of grain in its ports. Russia, starting the war, imposed a naval blockade, as it is possible to do under naval warfare, and Ukraine at that time found itself with a lot of grain in the storage and not possibility to export it in a period that the Western financial support was not pouring in, so the war-strained economy needed this money. On the other hand, there was Russia, who had also a problem with the sanctions that had been started immediately after the invasion of Ukraine, though agricultural products of Russia were not under sanctions. They can be traded freely. They have not been imposed, but Russia was complaining and arguing that other restrictions in sanctions that were put in place made international banks, insurers, and shippers reluctant to come to Russia and take their grain. And there was also the interest of the third parties, countries, especially in the developing south, in the global south, in Africa, which were facing, due to drought and climate change, famine conditions already, and they were depending, like Egypt or Ethiopia or Kenya or Uganda, were heavily depending on grain from Russia, from the Black Sea area, I mean Russia and Ukraine. So all of this made the United Nations Secretary General, I mean the United Nations system, to devise a plan to establish an corridor. I have just one map. This is my only slide. Probably you can show it. To establish a mechanism in order to allow the safe navigation inbound and outbound from Ukraine and Russia, only for foodstuffs, grain, sunflower oil, and also fertilizers, because this is also quite important. And less dependent states, like European states, were also interested in this because of the surge of prices. There was no conditions of famine in these countries like in Africa, but the European countries had also an interest that the trade from Ukraine, especially sunflower oil, would be unhindered so that the prices would come down. So this made the Secretary General of the United Nations to devise, along with the two different segments, UNCTAD, the United Nations Trade Conference, and the Humanitarian Office for Humanitarian Affairs, a plan to create this corridor. Maybe you can display just the map. I will continue. I will try. Yeah. So, the Secretary General, Antonio Guterres, presented this plan in place. There is it's a great initiative, and this map presented this the rough idea to Presidents Zelensky and Putin and Zelensky chronologically, and upon the positive reply of these two governments, they started the negotiation of the actual deal, which was inked in July 2022. Actually, it was prepared, as I told you, by two UN authorities, UNCTAD and OSHA, and it was signed in Istanbul on the 22nd July 2022 with the between the two countries, but also because it has been a UN plan by Secretary General Guterres, and because it has been facilitated by Turkey, who had kept a very balanced position in this balance. I'm not saying it in any value way, but it was neutral. I mean, on the one hand, it was against the invasion, but on the other hand, it never adopted or implemented any trade sanction against Russia. So it was also signed as a full party by Turkey. It was concluded for the beginning for 3 months, and it could be extended unless one of the two parties, of the two main parties, I mean, Ukraine and Russia, not the facilitators, would express their wish to terminate it. It worked for 1 year, actually, and on 1 year after its signature, July 2023, Russia terminated it. Russia had started already to complain that it was unfairly treated because this corridor had 2 points. One, it was to help Ukraine take out their grain, but on the other hand, also to help Russia for fertilizers and grain, and they said that they have been treated unfairly, and they have terminated it. Since then, and for 1 year, there have been recurrent efforts to revitalize it, but to no avail now. So I will speak how it has been applied for these years and potentially may be applied in the future, because neither Ukraine nor Russia have excluded its revitalization. They just put the conditions. So Ukraine said not for Russia, and Russia said not for Ukraine if not Russia is not benefiting also of this safe trade corridor. So the deal can be analyzed through different lenses with the economic sanctions or other war. But from the point of view of the law of the sea, is an application that is based on premises mainly of law of naval warfare. First is the issue of the naval blockade. It assumes that the naval blockade that Russia has imposed upon Ukraine as a belligerent party is a legal one, provided that all the conditions that the law of naval warfare are met with. And we have a very recent application in the Marmara case, where the blockade imposed by Israel against the coast of Gaza Strip and how it has been implemented. The second, which is very important for all Black Sea nations, especially the Western Black Sea nations, that is Romania and Bulgaria, is this limitation of the traditional understanding of the law of naval warfare. I mean, traditionally, a legitimate theater of naval warfare are the territorial waters of the two belligerent parties and every part of the high seas. Every part of the high seas is a legal theater that they can have hostilities. But this is a traditional rule that does not take into account that the evolution of the creation of exclusive economic zones, that for some, especially in Russia and Ukraine, there are some say that this exclusive economic zone for matter as navigation is concerned is like high seas. So for that purposes, it is legitimate to fight, to hold war operations in the exclusive economic zone of the third state if the target is one of the belligerent or of non-neutral. On the other side, I think there is an issue that needs to be discussed, needs to be probably taken into account. In San Remo manual, it has not been, though it is a rather recent effort to codify the law of naval warfare, that neutral states in their exclusive economic zones cannot be limited by this general application of the legitimate theater of war, but whenever the belligerents interfere with their legitimate rights, the rights, sovereign rights or jurisdiction, whatever this jurisdiction means, if they interfere, then this is not a legitimate part. So we have to, there is an issue there because the premise of this deal is that Russia and Ukraine could potentially use armed force against their enemy, their belligerent, even in the exclusive economic zones of Bulgaria and Romania. That's why there is this saying. This is also brings another issue of law of the sea, the neutrality, whatever it means, neutrality in the current world. And we know that the Western, not NATO allies have not taken any neutrality positions. They are not part in the classical term, but they are not neutrals either because they are furnishing not through the Black Sea, because there is this legitimate arm, but they are furnishing, they are supporting the war effort of Ukraine, of one of the belligerents, furnishing ammunition, weapons, and other support. And this brings the question of the contraband of war, the old question of the contraband of war, that the neutral sitting is covered, so they are safe from war operations at sea, unless they transport items that can be considered contraband of war. That means items that can be used for the war effort of either party. If they are transporting these items, the contraband of war, then they become legitimate targets. They can be the cargo and the vessel can be confiscated, seized in the beginning, and then under the conditions of price courts, it can be even confiscated. So this is the main premises. However, neither Russia nor Ukraine are placing themselves with regard to the operations in an armed conflict configuration. Russia, for its part, says that this is a special military operation, so it's not something that has to do anything with war. Of course, the armed conflict, we are not in the period that you need a declaration of war. An armed conflict is an objective situation. If you have hostilities with armed force, then you have armed conflict, whether one or the other belligerent consider it as armed conflict. On the other hand, Ukraine has never placed itself, for reasons that have been explained yesterday, for jurisdictional reasons, steadfastly on the UNCLOS. Actually, for the head, I'm afraid, sorry. For purposes of jurisdiction, in order to be able to submit the notification under Annex 7, as it was yesterday said by Professor Svetlov and Professor Caligiuri, they say that it's a matter of application interpretation of UNCLOS. So both of these countries, they, on the one hand, they placed in the law of the naval warfare without invoking the rules. And what is quite interesting is that in the deal, the official name of the deal, the Black Sea Grain Deal, is that initiative on the safe transportation of grain and foodstuffs from Ukrainian ports. In this document, there is no reference whatsoever to UNCLOS, no reference whatsoever. Though they say that the express purpose of this is, and I quote, to facilitate the safe navigation for the export of grain and related foodstuffs and fertilizers, and of course, from three designated Ukrainian ports. You can see the port of Odessa, of Yuzhny, and Chornomorsk. These are the three.
And Mariupol?
No, Mariupol is not covered.
Oh, it's Mariupol.
Yes, but it's not covered by the deal.
I know, but now Mariupol is closed.
They are blockaded by Russia. There is this. No one says that there is.
Mariupol, Nikolaev, it's very big, and the mother is river.
Yes, but
it's closed 100%.
all are blocked. Mariupol is not blockaded because it's under occupation. It's another.
Please block it.
Yeah.
The mother is 100% closed.
Yes, they are under occupation. It's different. Nikolaev. Ukrainian, they say Nikolaev in Russian. Yes, it's not occupied, but it's not covered under the this. The only these three, Chornomorsk, Odessa, and Yuzhny, are covered by this deal. Were covered, and actually, in order to return to what is the basis, the express basis of this text is not UNCLOS, nothing. It's not the law of the law of the naval warfare. Though they start with this, the deal explicitly refers as its legal basis the International Convention for the Safety of Life at Sea, the SOLAS, and the International Ship and Port Facility Security Code, which is quite unexpected that you base this thing, which is a safe corridor in the environment of a naval arm, in the safety of life at sea. I mean, something of the peaceful uses, and the Ship and Port Facility Security Code. Being that as it may, let's present, because I think I'm running out. The main provisions is that under the Black Sea Grain Deal, merchant-based vessels can navigate safely without being the object of any harassment or attack through the Black Sea from or to inbound or outbound from the three Ukrainian ports, Chernomorsk, Odessa, and Yuzhny, for the trade of grain and also what I said, foodstuff and fertilizers. The corridor starts outside at the outer limit of the territorial waters of Ukraine and stops at the entrance of the outer limit of the territorial waters of Turkey when they are inbound or outbound from the Bosphorus Strait. Ukrainian vessels are allowed, despite the blockade, to guide through the minefields that have been set on these ports safely in their territorial waters. So if a vessel hits to or departs from Odessa, while the vessel is in the territorial sea of Ukraine, the deal is not applicable. Only the Ukrainian pilots can lead them through the mines. If they arrive, there is this assembly area where there are inspections. I will return to the inspections because the inspections can take place in all the safe corridor, which is over 300 miles long, 310, and this is 3 miles wide. They can be inspected. But the premise of this corridor is, and I quote, this initiative, the deal, assumes that all parties will provide maximum assurances regarding a safe, a secure environment for all vessels engaged in this initiative. End of quote. This is the main commitment that the states undertake. That means, I can make details. First, that the parties committed to not undertake any attacks against merchant vessels and other civilian vessels and port facilities engaged in this initiative. That means that also the ports are protected, especially the storage of grain, fertilizers. The deal provides further that for the possibility of demining parts of all these corridors that have been mined with a foreign mineswiper if they are agreeing on this foreign state. So not Russian, not Ukrainian. Some foreigners can do that upon the agreement of the states. So this is also for the safe navigation, because especially the northern part has been infested with mines, and it's important to clean it. And in order to prevent provocations and incidents that may hinder the implementation of the deal, the parties had agreed that, I quote, no military ships, aircraft, unmanned aerial vehicles, drones, UAVs, may approach the maritime humanitarian corridor closer than the distance agreed by the parties without the authorization of the parties and after the consultation with all parties. So it's not only that they commit themselves not to attack, but also not to approach by any military device unless they agree. So in order now to
30 seconds.
Okay, so thank you. In order for the implementation, they provide for a system of control, monitoring in the assembly area in the beginning, throughout the corridor. And this is organized by a joint coordination center, which is a UN body located in Istanbul. It started only 1 week later, and it has teams four-party teams where there are inspectors, Russian, Ukrainians, Turks, and UN, and they are allowed in the assembly area that is close to Ukraine, but throughout the monitoring, they can intervene and check whether they abide by the deal or they are transporting others. And let me just finish with some conclusions that, let's say, the deal left open the question, and not probably to otherwise, the question whether the exclusive economic zone of a third state is a legitimate theater of war, traditionally or not. And just a word, though it has treated as a confidence-building measure at the time, it didn't deliver on time. Actually, it did not facilitate. They thought that because they could reach an agreement, the war parties, the belligerents, for this thing, probably this could create dynamics of negotiation. It didn't. The deal failed at the end. It helped a lot the Ukrainians, that's true. But after that, even the Ukrainians did not need it, and I finish with this. First, because their production, due to mobilization of agriculturists and the war dropped, they don't have grain anymore. They trade it because the war does not allow them. And now they have a lot of money given directly to them by the West. They don't need to produce their own. That's why probably, and Russia thinks that it's unfairly treated, and it did not deliver as a confidence-building measure. Thank you very much, and thank you for your leniency.
Thank you, Professor Stribis, for your interesting communication. So, if exist the questions regarding the topics to that session. If not, I would like to thank to all the speakers to that session. I would like to thanks to my colleague Professor Tassense, who helped us to the technical stuff. And I proposed you a short, very short coffee break, because with 11:30 we will start into the last session. Thank you very much for your attention.